Good morning. This is Rich Sierra. This is episode number 8 of Business SOS podcast. Very excited about that you're joining us this morning. Remember, Business SOS, 8 common legal mistakes that business owners make and how to avoid them. It's available in Barnes & Noble, Amazon, and also in your local bookstores. Today we're going to talk about, it's going to be like a 2-part series, but I'm going to start today. Mistake number 7 in my book, Business SOS, is the lack of understanding of basic contract law. As a business owner, you're faced with a variety of contracts, pretty much almost on a weekly basis, a monthly basis, and there some contracts they're routine contracts that you're dealing with. For example, a restaurant, every week they have to buy inventory from the various suppliers, so they get a purchase order for the inventory, they sign it, and they agree to pay. That is a contract. That's something that is done very routine. A contract that doesn't happen every day is a lease agreement, for example. A lease agreement you do maybe every 3 years, 5 years, 10 years, depending on how long is your lease. That's something that takes a little longer to that'll come up. But one of the I believe that every business owner needs to have an understanding of basic contract law. You don't have to have the level of depth that a business attorney would have, but at the very least understand what is presented to you, what is, when you actually enter into a contract. And I want to talk a little bit more about that. And I remember when I was actually undergrad at UT, University of Tampa, that I took my a contract law class, and it was a very simple formula. Okay, it's offer plus acceptance, consideration plus consideration. It's a contract, and and I still remember that, and actually put that formula in my book. So a lot of times, basically, what is basically an offer? An offer is to do something, and they offer you services, they offer you a product, you look at it, you agree on the price, and you agree to pay the price, and that's the consideration, and then you accept the offer. It's very clear. And we wish all the contracts were that clear, but it's usually not the case. A lot of contracts, sometimes you're dealing with construction contracts that deal with a lot of different items that have to be performed, and there are line items that you have to do and you have to review. And then sometimes you have contracts to say, okay, we're going to review this particular aspect of the remodel, for example, at a later date. That creates some type of ambiguity in the contract, so it is not clear when a contract was established because the terms are not very clear. So one of the things that I advise, my clients is that if a contract is presented to you, the terms have to be clear. Clarity in contracts is essential. If you do not understand the contract, do not sign it. Get help, get advice, have an attorney interpret it for you. But it is important that you understand each provision of the contract before you sign it, because you're bound by those terms. And a lot of times, you're not really sure what exactly you agreed upon. Another mistake that I see is that people make a lot of verbal agreements. And there's nothing wrong to an extent that a verbal agreement may not be enforceable. It is in some conditions, some terms that is outside of the scope of this particular topic. But it is not a good idea to make verbal agreements that involve money or anything that involves value. And I'll give you an example. Sometimes people agree to, and this happens when you have a regular relationship with somebody. You already have a relationship established, and then say, in this case about talking about remodel, and you agree with your contractor to some terms, they're in writing, everything is fine, they're working, say, in your kitchen, and they're, replacing the cabinets, replacing the the counter, and you tell your contractor, listen, I also need something in the bathroom done. You have the relationship, say, you know what, okay, I'll get it done, it's fine, we'll take care of it. But you never talked about price. You never talk about how much it was going to cost. You never talked about whether there was going to be any type of, rerouting of the plumbing. The contractor does it, you know him, it's fine. And before you know it, you get a $5,000 bill. And he said, well, what is this about? I said, well, you asked me to remodel your bathroom. No, I just needed to fix the toilet. And I'm using that as an example simply to be clear. But the work was done. So he's entitled to receive the compensation because he did the work that he believed you asked him to do, even though that's not what you intended to do, to ask him. So that ambiguity, that creates a conflict, and that was obviously a clear misunderstanding of something to be fixed in a bathroom versus something to be remodeled in a bathroom. So what is the cure for that? A written contract, a change order. So if you're going to if you have the relationship with a vendor, with a customer that asks you to do something more that you usually are accustomed to, just at least send an email. If nothing else. So listen, just to confirm, this is what I'm going to do for you, and this is going to be the price, and just confirm that we're on the same page. That email is a contract because you have the meeting of the minds, you have the offer, you have the acceptance, you have the consideration, you have the confirmation as well. But in order to have that certainty, just put it in writing. Change order is actually preferable. So one of the questions that I ask my clients when I get calls sometimes asking me, hey, I need to help me draft a simple contract. Could be an employment contract, could be a partnership agreement, could be a non-compete agreement, or could be a non-interference clause. They say, we had the agreement, or a favor of mine is like, yeah, we're going to be buying this business. It's all set up. We already talked about it. Just do a simple contract. We want to go ahead and get it done Friday, in 3 days. And I'm like, okay, let's talk about this for a second. So the first question I ask is, who are the parties? Who are the parties to the contract? And you can also verify, and I remember a prior episode, I want to make sure that the parties exist. That whoever the LLC is, whoever the corporation is, I can actually find them somewhere in some corporate record in the state. It's very easy to put an Inc. or an LLC next to anybody's name. And if you not take the time to look it up, then you don't know whether the company exists or not. How do you know the parties? How do the parties know each other? And my client said, how do you know the other party you're contracting with? It's important to know who you're dealing with. Are the parties legal entities? It's important to know that. It's an LLC, Inc., PLLC. I like to know the background of these companies before we go into a contract. Important, what are the contract terms? When I'm drafting contracts, I like to work through outlines. I like to work through points, key points. Because trying to negotiate a contract through a large document is very, very confusing, convoluted, and it takes longer. The way I look at it, if you're able to agree on the key points of the contract, the other matters can be resolved, can be handled, they can be done through the drafting process. But the major points in the contract, in a buy-sell agreement, for example, are, okay, you're going to buy the assets of the company. What is the purchase price? Okay, say $100,000. Okay, how much down payment are you going to put in? Deposit, $10,000. So you have $90,000. Okay, at $90,000, you're going to have that cash, or it's going to be financed. Owner is going to finance $40,000. The balance will be cash. Okay, so those are key contract terms. Okay, it's going to be any type of intellectual property be transferred, website, trademarks. Okay, what happens to our receivables? Is the owner going to stay for a period of time to assist? It'll be a non-compete from the owner. So all those things, those are key terms that we ask to make sure that everything is clear, that there's no ambiguity. How is the offer going to be extended? How is it going to be accepted? When is the closing? Is there any type of exit clause for due diligence? All those things that we need to ask, and that's going into the contract. And what else is important is that the people who are actually signing the contract are able to have the authority to sign the contract. Sometimes you're dealing with a manager, so you want to make sure that the people that you're dealing with actually can enter into this contract. So that's very important. Something else that I look at is, what are the obligations of the parties? And what happens if there's a breach of the contract? What is the termination clause? You know, the fact is nothing lasts forever. So the contract has to have a termination. So I look at that, and that's something that I'm sharing with you. So when you look at the contract, look at those key terms. How will this contract and this contract be terminated? In some cases, you can give 30 days notice. Some cases, you can't unless there's an actual breach of contract or there's actual mutual consent between the parties to terminate it. Is there a penalty to terminate this contract early? What are the deadlines? And more importantly, what happens if the contract is breached? If we have a conflict with this contract and all of a sudden we need to get lawyers involved, how are we going to resolve that? What is the dispute resolution process in this particular contract? And that's one of the first things that I look at. Say, okay, how are we going to resolve this? Because disputes happen with contracts. Sometimes contracts are breached. It's going to be a mediation first, or arbitration, or it's going to be mediation and then going straight to court. So those things are important to look at. But also look at whether there's prevailing parties, attorney's fees as well. If the contract is breached and you're able to prevail, are you able to recover your attorney's fees? And if you recall in a prior episode, when I went to in great detail about lawsuits, I talked about attorney's fees provision in a contract doesn't mean you automatically get the attorney's fees. What it means is that you're entitled to ask the court for them, and it's up to the court to agree with your request. So it's not automatic, and that's at the very end of the case. So we have to look at that as well. So another thing I want to share with you, the timing of the contracts. When do you have to sign this contract? And what is the deadline? What happens if you miss that deadline? Can it be extended? And I'll give you an example. In the case of buying a business, sometimes due diligence has to be extended. It could be, for example, whether they're waiting for some financing, whether there's additional due diligence have to be reviewed. So what we try to do in this case, if there's going to be an extension to a due diligence process or any type of buy-sell, you basically write an addendum to the contract. The contract has been extended for 15 days, 20 days, whatever the case may be. So those are the things that we look at. Just to kind of recap this section. So when you look at a contract, a contract is presented to you, I want you to look at the parties. Most likely who the parties need to decide. The key terms, they have to be clearly outlined. Is there any penalty? involved in the contract? Are there any type of what is the dispute resolution process? And I want you to ask yourself, okay, if he breaches the contract, if the other side breaches the contract, am I able to enforce it? That is a very important question, because you got to game that out. You got to think, okay, listen, anything can happen, but what if in this case, the seller does not meet his obligations or her obligations? Am I able to enforce it? How much money is going to cost me to enforce this contract? Because the ability to enforce a contract is based on your resources to be able to enforce it. So it's not all that clear cut. And again, if you have any questions as to whether you understand the contract, you can contact an attorney. I think that having an attorney review the contract, especially if another attorney prepare the contract, you're already at a disadvantage. So having an attorney review it and just put you at a level playing field and give you that peace of mind. I think a termination clause is extremely important to have. Another thing that I see here is that another common mistake that I have is like when people are signing these contracts. In the last episode, I talked about online businesses that could be scams, but it doesn't have to necessarily have to be that way. When you have a contract in front of you, I said, you know what, did anybody help you with this? And the answer is no. He was my friend. I trusted him. I know the people. I had no reason to read it or review it. They told me everything is fine. And then you have an issue here that, blindly trusting somebody when a contract is presented to you is a mistake. You should at least have a professional review it for you before you actually sign it. And again, the rules are, if you do not understand the contract, don't sign it. And again, what I'm giving you today cannot be constituted as legal advice. It's simply concepts that I'm presenting to you for you to be aware of, and hopefully it'll give you better of an insight on when you get review a contract, to be prepared, at least be aware, you might have a pause before you sign it. This is episode number 8 of Business SOS. I hope you enjoyed it. How can you reach me? And I wanted to also remind you to please send me your questions. If I select your legal question and I'll talk about it in the show, I'll go ahead and send you an autographed copy of Business SOS. You can reach me at richsierra.com. If you're interested in my legal services and finding more about our law firm, our website is floridasmallbusinesslegalcenter.com. You can find us in Facebook at FSB Legal, YouTube at youtube.com at Richard Sierra. This podcast is also being videoed as well. You can find us on Instagram at FSB Legal. Our phone number is 866-842-5202. Remember, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. If you like the podcast, follow the show, please. We're on Apple Podcasts, Spotify, and wherever you enjoy your shows. Also, we have our contact information in our show notes as well. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.